Good morning, everyone. This is Chair French, and I am convening the evidentiary hearing in the matter of the investigation into Black Hills Kansas Gas Utility Company, DBA Black Hills Energy, regarding the February 2021 winter weather events as contemplated by docket number 21 GIMX 303 MIS and the consolidated docket of in the matter of the application of Black Hills Kansas Gas Utility, DBA Black Hills Energy, for a waiver of its tariff in docket number, these are docket numbers 21 BHCG 334 GIG and 21 BHCG 370 MIS. As you all are very aware at this point, due to the pandemic, we are conducting this hearing via Zoom, and we are broadcasting to the public on the KCC's YouTube channel. So please do, we ask you to bear with us if you experience any technical difficulties. I am going to begin with entries of appearance for a council of record of all the parties, and I will begin with Black Hills Energy.
Good morning, Commissioners. James G. Flaherty, Ottawa, Kansas, and Jeff Danjo on behalf of the applicant, Black Hills Energy.
Thank you. Good morning, Jim. NGTCC.
Good morning, Commissioners. James Zakora and Connor Thompson on behalf of NGTCC. Thank you.
Morning, Jim. National Beef.
May it please the Commission, Frank Cairo with the Posanelli Law Firm on behalf of National Beef. I don't know if Brett Wilson is on the General Counsel.
Okay, very good. Thank you, Frank. Kansas Attorney General's Office.
Good morning, Melanie Jack, Assistant Attorney General for Derek Schmidt, the Kansas Attorney General. Thank you.
Good morning, Ms. Jack. Freedom Pipeline LLC.
May it please the Commission, Kyle Weiniger on behalf of Freedom Pipeline LLC.
Morning, Mr. Weiniger.
Morning.
Curb.
Good morning, Commissioners. Joseph Astrap on behalf of the Citizens Utility Ratepayer Board, or CURB.
Morning, Mr. Astrab. And finally, KCC staff.
Good morning, Commissioners. Carly Massentine and Terry Pemberton appearing on behalf of Commission staff and the public generally.
Morning, Carly. Does staff have a recommendation regarding notice of this proceeding?
Yes, staff has examined notice and reports that on October 28th, 2021, the presiding officer in this matter released an order granting motion for procedural schedule. That order set a hearing for today in the event a settlement was reached among the parties. The order was properly served among all parties to the docket 10 days prior to the proposed hearing date, consistent with the Kansas Administrative Procedure Act. The parties have subsequently conferred for a pre-hearing conference and engaged in communications relating to hearing procedure for a hearing on today's date. Therefore, staff recommends a finding of proper notice for this hearing.
Thank you, Ms. Massentine. Are there any objections to notice in this proceeding? Hearing no objections, I will find that notice is proper and the Commission has jurisdiction over this proceeding at this time and place. I want to begin now with a few preliminary matters, but before those preliminary matters, just a few notes on the conduct of this proceeding over Zoom. First, if any party encounters any technical issues today, I do encourage you to speak up and ask us to go off the record so we can resolve those technical issues off the record. Second, witnesses participating via Zoom are asked to keep their microphones off when they're not scheduled to talk, and that would obviously go for attorneys as well. Third, if there are any witnesses in the Commission's hearing room, please use the disinfectant wipe. I don't think we have anybody in our hearing room, so that shouldn't necessarily apply. Fourth, if the Commission needs to deliberate on any rulings, we will go off the record, enter a Zoom breakout room, and you will not be able to see and hear us at that time, and then we will return to the main session. Fifth, since we're participating at a distance, please be especially careful to identify exactly what you're referring to when discussing pre-filed testimony and exhibits if necessary. We do have copies of everything that's been pre-filed, so we should be able to follow along if you identify it clearly. Now, for a preliminary matter on witnesses, I understand that there are questions for a couple of witnesses, but for witnesses that there are no questions for, I understand there is a request to simply waive into the record the direct testimony and exhibits filed by those witnesses. And the witnesses that I have listed here that there is a request to waive their testimony in would be pre-filed direct testimony and exhibits filed by Rob Daniel and Kent Kopetsky, and then also the pre-filed testimony in support of the settlement by Rob Daniel and Mike Gorman. Do I have that correct?
Yes, you do, Your Honor.
Okay.
We'd request that testimony be referred into the record.
Are there any objections to admitting that testimony into the record on this basis? Hearing none, the pre-filed direct testimony and exhibits filed by Rob Daniel and Kent Kopetsky are referred into the record, and the pre-filed testimony in support of the settlement filed by Rob Daniel and Mike Gorman will also be referred into the record. Now I will move to the procedure for the hearing. I understand the parties do wish to make brief opening statements, and we have a request that staff would go first, followed by Black Hills, Curb, NGTCC, and National Beef. And just to note at this time, I do understand that the parties indicated they will not be making closing statements, and they have also waived post-hearing briefing. So at this time, if there are no further preliminary matters, we will begin with opening statements, starting with KCC staff.
Thank you, and again, good morning. As you all know, in mid-February of 2021, Winter Storm Uri imposed extreme and unprecedented freezing weather conditions across the United States. Winter Storm Uri prompted health and safety concerns, sudden and sustained natural gas supply disruptions, widespread infrastructure and operational failures, and freeze-offs of facilities that were necessary for the delivery of natural gas. In response to Winter Storm Uri, on February 15th, 2021, the Commission issued an emergency order in docket number 21 GIMX 303 MIS, which acknowledged the state of disaster emergency proclamation issued by Governor Kelly, the higher than normal wholesale natural gas prices, and the potential for reliability issues related to the prolonged February 2021 cold weather. The emergency order required jurisdictional natural gas and electric utilities to do everything necessary to ensure natural gas and electricity service continued to be provided to their customers in Kansas, and to take steps to insulate customers from potentially devastating financial effects of paying for these costs through the normal course of billing. The Commission authorized jurisdictional natural gas and electric utilities to defer into a regulatory asset any extraordinary costs associated with ensuring that their customers that their customers continue to receive utility service during the cold weather event. The authorization included the ability of each respective utility to include carrying costs at its weighted average cost of capital, with the decision relating to ratepayer recovery to occur after all extraordinary expenses are reviewed for prudence and reasonableness. On March 9th, 2021, the Commission issued an order in docket number 21-303, in which the Commission adopted staff's recommendations to open company-specific dockets to document issues raised in the Commission's investigation into each major jurisdictional utility's performance during the February 2021 winter storm, and to record the company-specific findings of the financial impact plans contemplated in the Commission's 21-303 order. The Commission subsequently opened the instant docket to investigate Black Hills' performance during Winter Storm Uri, and also to determine a plan to minimize the financial impact of the storm on Black Hills customers. Staff's investigation included conducting substantial amounts of discovery, numerous meetings and other communications with the various parties to the docket, and an in-depth analysis into both Black Hills' handling of Uri and its plan to reduce the financial impact of the storm. On March 23rd, 2021, Black Hills filed an application in docket number 21 BHCG 370 MIS for a temporary waiver of penalty provisions of its Commission-approved tariff, until such time that Black Hills had the opportunity to fully evaluate any penalties that may be assessed against it by the various upstream natural gas pipelines from which Black Hills takes service. Practically speaking, this temporary waiver would allow Black Hills to forego the imposition of penalties against its transportation customers. The commission granted the temporary waiver on April 22nd, 2021. On May 28th, 2021, Black Hills subsequently filed a request to make the waiver permanent after concluding that such a waiver was in the best interest of its transportation customers and that sales customers would not be harmed as a result. Based on that request, staff moved to consolidate the 21-370 docket with the instant docket so that all aspects of Black Hills operations relating to Winter Storm Uri could be comprehensively evaluated in this consolidated matter. As staff witness Justin Grady is here to testify, staff's review of Black Hills' performance during Uri was extensive. During and after the event, staff was in constant communication with Black Hills with respect to system operations and supply issues. Additionally, staff conducted an analysis of the purchased gas costs incurred by Black Hills during the storm in light of Black Hills' filed gas purchase and hedging plan for the 2020 to 2021 winter, and in light of the Commission's prudency standard for gas purchase cost. Staff has determined Black Hills acted consistently with what was called for in its gas purchase and hedging plan with respect to its gas purchases during the winter weather event, and believes the Commission should consider the gas purchase costs incurred by Black Hills during that time prudent, reasonable expenses that were required to continue providing a vital service during this extraordinary winter weather event. On June 16th, 2021, Black Hills submitted in this docket its plan to minimize the financial impact of Winter Storm Uri. The initial proposal was for Black Hills to extend recovery of approximately $87.9 million in extraordinary gas costs incurred during the storm over 5 years, with carrying costs at Black Hills' weighted average cost of capital of 7.98% over that 5-year period. This proposal would have resulted in an average monthly bill increase of $12.23 for an average use residential customer. After months of discussions and negotiations related to Black Hills' proposal, the parties crafted the settlement agreement before you for consideration today. As you will hear from Black Hills in greater detail, this agreement provides that Black Hills' purchased gas costs of approximately $87.9 million were prudently incurred and that Black Hills should be allowed to recover the costs from customers over a period of 5 years. Black Hills shall be allowed to recover carrying charges of 1.3% for the year 2021 and 5.71% for the 5-year period beginning in February 2022. This plan increases the average residential customer's bill by $11.47 per month during the 5 years of the recovery period. Staff understands that any increase to residential customer bills is an unfortunate consequence of Winter Storm Uri and could cause hardship for many customers. Yet staff is confident this result is the best possible result given the extraordinary nature of Storm Uri and the resulting extraordinary costs. The plan set forth in the settlement agreement does spread the overall cost over a period of 5 years, reducing the monthly impact as a whole and making these prudently incurred costs as affordable to customers as possible, while balancing and considering additional carrying charges and potential intergenerational inequities that could occur if the costs were to be recovered for a longer period than 5 years. Furthermore, the agreed upon carrying charges balances Black Hills' interest in obtaining reasonable assurance that it can earn sufficient revenues and cash flows to meet its financial obligations and maintain its investment grade credit rating with the customer's interest in extending the overall payment period to reduce the monthly cost burden. In conclusion, staff wholeheartedly supports the settlement agreement, and as staff witness Justin Grady has stated in his pre-filed testimony in support of the agreement, staff believes it satisfies the Commission's standards for unanimous settlement agreements and believes this agreement is a just and reasonable outcome and one that is equitable to both Black Hills and all of Black Hills customers impacted by this unfortunate event. Thank you.
Thank you, Ms. Massentine. On my schedule, I have Black Hills to present next, and Mr. Flaherty, I believe you have a PowerPoint, is that correct?
I do. If Mr. Cohen can put that up, that'd be great. Thank you.
David, are you able to share the PowerPoint from Black Hills?
I have it. I gave it to Michelle, but I can try to put it on my screen.
There we go. Michelle's got it up.
Thank
Thank you,
you.
Michelle.
Good morning. The parties are here this morning to present to the commission for its review and approval a settlement on Black Hills' plan to minimize the financial impact relating to the extraordinary gas costs that it incurred on behalf of its sales customers during Storm Uri in February 2021. If you could turn to slide 2, please. Slide 2 shows that Black Hills service territory in Kansas is spread out throughout the state. It serves 66 communities, has over 116,000 sales customers, 1,200 transport customers who purchase their own gas, and about 141 employees that operate the different systems throughout the state. As explained by Mr. Kopetsky in his direct testimony, and he is the senior manager of gas supply services for Black Hills. Black Hills purchases gas for its sales customers off of 9 different interstate, intrastate pipelines, gathering systems, and distribution systems, and also obtains storage services from 5 different pipelines. Mr. Kopetsky's in his direct testimony identifies the unforeseen and unprecedented spikes in the natural gas prices that occurred during Storm Uri. And to place that extraordinary gas costs in perspective, as explained by Mr. Rob Thomas, who in his direct testimony, who's the manager of regulatory and finance for Black Hills total gas costs that it incurs on behalf of its sales customers for a typical February run around $4.6 million. However, in February 2021, the total gas cost for Black Hills sales customers were nearly $94 million. Based on the commission's orders in this docket and in the 21-303 docket, Black Hills went ahead and billed its sales customers $5.7 million in gas costs for February of 2021 and deferred $87.9 million to be recovered under a financial plan to be filed with the commission that would minimize the impact of that extraordinary gas cost on sales customers. Pursuant to the commission's orders, the utility was allowed to calculate carrying charges on the deferred gas costs in order to recognize that by deferring those gas costs, there were costs involved in that deferral based upon the utility's current weighted average cost of capital. Next slide, please, Mr. Cohen. On June 16th, 2021, Black Hills filed its proposed financial plan. It sought to recover the $87.9 million in deferred gas cost over a 5-year recovery period using a volumetric surcharge. Pursuant to the commission's order, Black Hills used its current weighted average cost of capital rate to calculate the carrying charges on the deferred amount. Black Hills allocated the deferred gas cost and carrying charges to customer classes based upon those classes' February 2021 usage. The plan excluded irrigation sales from the surcharge. The plan also provided for an annual true-up and then a final true-up at the end of the 5-year period. Next slide, please. Slide 4 shows the impact that the surcharge under Black Hills' original plan would have had on a typical sales customer. For a typical residential sales customer who uses monthly about 56.1 therms, the average monthly Storm Uri surcharge would be $12.23 per month. For a typical small commercial sales customer who has a monthly usage of 99.5 therms, the average monthly surcharge would be $25.46. Next slide, please. Pursuant to the procedural schedule that was issued by the commission in this docket, all of the parties conducted and participated in a technical and settlement conference that resulted in several virtual meetings and ultimately a settlement that was filed with the commission on November 9th, 2021. The main terms of that settlement are set forth on this slide 5. It's important to point out that all the parties in this docket either support or do not oppose the settlement. The settlement states that the extraordinary gas costs that were incurred in February 2021 were prudently incurred. The carrying charge rate applied to the deferred cost was reduced from the company's 7.98% weighted average cost of capital rate to a rate of 1.30% through December 31st, 2021, and a rate of 5.71% for the period of January 1st, 2022 through the end of the recovery period. The recovery period will be 5 years. That will begin on February 1st, 2022 and end on January 31st, 2027. The lower carrying charge rate included in the settlement results in reducing the total carrying charges from $20.7 million to $13.7 million. The costs are allocated among sales customer classes based upon their February 2021 usage. The surcharge will not be charged to irrigation sales or customers located in the city of Ford, Kansas, who became customers of Black Hills after Storm Uri. There is an annual true-up and a true-up at the end of the 5-year recovery period. Also, in the event that Black Hills receives any refunds or funds as a result of either profit disgorgement, civil suit relief, or market manipulations due to state and federal investigations, including investigations being conducted by the Kansas Attorney General's office, those funds will be passed on to customers through the company's PGA, ACA on an annual basis. Turn to slide 6, please. Slide 6, the settlement terms reduce the Storm Uri surcharge from $12.23 per month to $11.47 per month for the average residential customer, and from $25.46 per month to $23.66 per month for the average small commercial customer. Slide 7, please. The settlement also includes terms as to how customers who switch services will be treated, and how customers who become new Black Hills customers will be treated. And those are outlined in this slide number 7. I know the hearing officer notified us that the commission did not have any questions for Mr. Daniel about the settlement, but in case something does come up during the hearing that raises a question, Mr. Daniel is here to respond to any questions the commissioners might have regarding this matter. Mr. Kopetsky is also available, as well as Mr. Jerry Watkins, who is the general manager of Kansas operations for Black Hills, who can also answer any questions that might come up during the hearing. Also, at the conclusion of the hearing, if the commissioners have any legal questions regarding the settlement agreement, Mr. Danjo and I would be happy to attempt to respond to those questions. Finally, Black Hills would like to formally thank the commission staff, CURB, and the other parties that participated in this docket for their professionalism and their diligence in their efforts to reach a settlement in this docket. Black Hills believes that the terms of the settlement are reasonable because they will, one, minimize the financial impact on our sales customers, while at the same time allow Black Hills the opportunity to return its credit metrics to pre-winter Storm Uri levels in a reasonable time period, and to reduce risk of a credit downgrade due to the impact of the storm. Black Hills would request that the commission approve the settlement. Thank you.
Thank you, Mr. Flaherty. We will now move to Mr. Jim Sakura for a brief opening statement on behalf of NGTCC.
I would be happy to do that on this schedule. CURB is listed ahead of me, but I'm happy to do whatever the commission would.
I have a
Likewise.
different schedule than you, but if CURB would like to go ahead, CURB, would you like to go next?
If that's okay, Commissioner, yes. Sure, thank you. May it please the commission. My name is Joseph Astrap, and I, along with Consumer Counsel David Nickel and Attorney Todd Love, represent the Citizens Utility Ratepayer Board, or CURB. Our duty is to represent residential and small commercial ratepayers on utility regulation matters before the Kansas Corporation Commission and to advocate for sufficient and efficient service at the most reasonable price. As part of this role, we are here today in support of the unanimous settlement agreement regarding Black Hills' financial plan to mitigate the impact of approximately $88 million of incremental gas costs incurred during Winter Storm Uri. CURB analyst Josh France provides testimony on behalf of CURB. He discusses the appropriateness of the settlement agreement in light of the extraordinary circumstances that occurred during President's Day weekend of February 2021, referred to as the weather event. It is no exaggeration to say that every Kansan has been or will be affected by the event. The commission opened this docket in order to track and mitigate the impact of the extraordinary fuel cost incurred during the weather event, to evaluate the company's actions at the time, and to develop new plans and lessons for future extreme weather and financial events. It is important to reflect on the magnitude of this amount when considering the entirety of the settlement agreement. The amount that the signatories are asking the commission to approve here is roughly $30 million more than the base rate revenue requirement submitted for consideration in Black Hills' most recent rate case before the commission. If approved, ratepayers will be required to pay this amount back over a 5-year period for a week's worth of gas use. All of that to say that CURB does not join in support of this agreement lightly, but rather after a review of hundreds of documents obtained from numerous discovery requests and dozens of technical meetings and collaborative discussions. Our support also comes from a recognition that each class of ratepayer should be responsible for the reasonable cost used to serve them. To that end, the agreement resolves the issues related to the marketer penalties from the 21-370 docket consolidated here. Mr. France concludes that the waiver of the applicable penalties is appropriate because Black Hills was able to avoid a net increase of its cost to serve those customers. As a result, Black Hills has warranted that sales customers will not be required to subsidize any extra costs from outside of the sales class from the weather event. Mr. France reviews the factors used to evaluate settlement agreements for approval. He points out the unusualness of the lack of testimony before the settlement was filed and discusses CURB's position on Black Hills' initial proposal. Mr. France testifies that allowing the company to recover the cost at its weighted average cost of capital, 7.98% as initially proposed, would be unreasonable and not reflective of the actual cost of debt. He reasons that a high carrying charge may create an unreasonable windfall for the utility at the expense of customers. This agreement calls for a rate of 1.3% from the time the extraordinary costs were incurred through January 1st, 2022, and 5.71% through the end of the recovery period. This will save ratepayers millions in financing costs and more closely reflects the borrowing and credit realities for the utility. The evidence today will show that the agreement conforms to applicable law. There is little precedential guidance on how to treat extraordinary costs due to volatile natural gas prices. However, rate-making principles of establishing just and reasonable rates and only recovering prudently incurred costs provides foundation for consideration. Mr. France testifies that Black Hills compiles a gas purchase plan and submits it to the KCC staff and CURB for review and approval before the winter season, which it did prior to the weather event. Mr. France states in his testimony that without the lens of hindsight, Black Hills acted adequately in response to the governor's and commission's calls to action to do everything necessary to ensure that all Kansans had service during the extreme cold. In light of Black Hills' compliance with its gas purchase plan and the unprecedented circumstances, Mr. France concludes that the extraordinary costs were prudently incurred. The decision to purchase gas at record-setting prices versus the risks to property and human life from not providing service cannot be understated. Hindsight scrutiny of these decisions during an emergency applies a lofty standard. However, CURB understands the desire to do this kind of review, but believes that the next phase of this docket regarding lessons learned will be the best place to discuss those matters. CURB is hopeful that the pending investigations by the Attorney General's office and other entities around the country shed more light on the historical spike in natural gas prices. A lower carrying charge and longer repayment period as laid out in the settlement agreement will establish just and reasonable rates through a more desirable debt to equity ratio for the company while protecting the residential class from unreasonable bill increases. However, CURB is mindful that even with this mitigated recovery plan, there will be customers who are disproportionately impacted by these changes. That is why CURB remains dedicated to advocating for tariff and rates that help low-income customers. While the weather event has highlighted the need to improve winter supply plans, it also brought a new emphasis to evaluating how best to ensure that all ratepayers have access to utility services without being overburdened by cost. CURB asked the Commission to approve this unanimous settlement agreement for all the reasons contained in Mr. France's testimony and that of the other parties. Thank you.
Thank you, Mr. Astrab. Assuming the rest of my schedule lines up with others, is Mr. Sakura? I have Mr. Sakura next on mine.
Thank you, and I'm happy to have deferred to my colleagues at CURB, but now I will proceed with the Commission's approval.
Very good.
The Natural Gas Transportation Customer Coalition appreciates the opportunity to present a brief opening statement in this docket. Our customer coalition joins CURB, the KCC staff, and Black Hills in support of this settlement that has been presented to the Commission. It was important for our group to join because we believe that this is the first case that presents to the Commission an important policy of short-term debt and carrying charges for the extraordinary costs. The Commission has authorized natural gas transportation in Kansas for more than 20 years. During the time, the volume of gas transportation has grown to the point that transportation volumes are now more than 50% of all natural gas used in Kansas. The combination of market-based natural gas acquisition coupled with KCC jurisdictional delivery has worked well for our state in the past and continues to work well. On the Black Hills system, our customer coalition includes public and private schools in Lawrence, Dodge City, and Liberal, the University of Kansas instructional and student residence facilities, hospitals and businesses of all types and sizes, including such community mainstays as car washes, laundromats, concrete and asphalt manufacturers, restaurants, and car dealerships. Our advocacy in this case and in other similar dockets at the Commission is limited to the issue of the amount of interest rate costs, often referred to as carrying costs, that a utility will be permitted to be collected from ratepayers. In its initial filing in this docket, Black Hills viewed the Commission's emergency order of February 15 to permit Black Hills to recover carrying charges at its weighted average cost of capital. In the case of Black Hills, that approach would yield an interest rate for carrying charges of 7.98%. The Customer Coalition instead advocated for what we believe to be the most appropriate Commission policy in this and other cases of extraordinary additional gas costs on the issue of interest rate for carrying charges. This policy is to align the actual interest rate of utility short-term debt used to finance the additional gas costs with the interest rate for the carrying charges to be recovered from ratepayers. This policy reduced the carrying charges interest rate from 7.98% as originally proposed by Black Hills to an actual Black Hills short-term interest rate of 1.3% for the period through December 31, 2021. This reduction in interest rate for carrying charges has been agreed to by all parties sponsoring the settlement agreement. This alignment of a utility's actual debt costs and ratepayer payments for the actual cost of utility services is both consistent with KCC precedent and also acts to manage these extraordinary expenses at the lowest cost to Kansas ratepayers. This short-term interest rate policy that sets the carrying charges at 1.3%, coupled with an agreement by Black Hills and KCC staff for a reduced carrying charge for the 5-year term to address the unique capital structure issues of Black Hills, results in a $7 million reduction, about 8%, in ratepayer costs over the term of the 5-year recovery period. For the reasons stated and our single issue of the appropriate recommendation to the Commission for the carrying charges, we fully support this settlement. Thank you.
Thank you, Mr. Sakura. Now I have for the final opening statement, Mr. Frank Cairo on behalf of National Beef.
Thank you, Chair French. May it please the Commission and good morning. First, I'd like to thank the Commission for allowing National Beef to participate in these proceedings. let's start by saying just National Beef seems to be one of the largest customers on Black Hills system, serving 2 facilities, one in Liberal, Kansas, and the other 60 miles away in Dodge City. Each facility there employs over 3,000 employees at each of these facilities. National Beef was impacted by this storm Uri. And only 60 miles apart from each facility, the Liberal facility incurred cash out additional costs in the amount of nearly $700,000 for that month. Some 60 miles away, the Dodge City facility incurred no cash out issues. And as you'll probably have heard later, from on an electric side, they incurred nearly $3 million of additional costs on the electric side, served by 2 separate utilities in both those plants. We support the settlement here. We believe, like Mr. Zakora, that reducing the cost down to what's actual cost and carrying charges is a fair support here. We believe in the equitable sharing of those costs among all parties here. And as Mr. Zakora said, on behalf of NGTC, staff and CURB, we support the settlement agreement. And we appreciate our ability to participate in this proceeding.
Thank you, Mr. Cairo. Well, if I have not missed anyone, I believe we've concluded opening statements and we will move to witness examination. We have already waived into the record the testimonies of several witnesses, but we do have 2 witnesses for which I believe there are at least questions from commissioners. So we will begin. On my list, I have as first CURB, the CURB witness, Josh France. And so at this time, Mr. Astrab, you may call your witness.
Thank you. This time, CURB calls to the stand Josh France.
And Josh, you may have to say something so that you pop up on everyone's screen.
Yeah, I'm here. Thank you.
All right, Josh, can you hear me okay?
I can, thanks.
Okay.
I will have the court reporter swear you in. You're on mute right now, Denise.
Okay, please raise your right hand. You do solemnly swear the testimony you're about to give and the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you.
May I proceed? Please tell the commission your name, spelling your last name.
Yeah, my full name is Joshua Paul Franz. My last name is spelled Frantz. I go by Josh.
Thank you. And Mr. France, what is your occupation?
I am a research senior regulatory analyst for the Citizens Utility Ratepayer Board.
And how long have you been in your current position?
About 3 years.
And are you the same Josh France who caused to be filed in this docket approximately 18 pages of written pre-filed testimony in support of a unanimous settlement agreement on behalf of CURB on November 22nd, 2021?
Yes.
And have you had a chance to review that testimony prior to appearing here today?
Yes.
And as you sit here today, do you have any corrections or changes to make to your testimony?
No, I don't.
And if I were to ask you all the same questions from your pre-filed testimony here today, would your answers to those questions be the same or substantially similar as to what's in your pre-filed testimony?
Yes, they would.
Chair, this time I would move to admit the pre-filed testimony of Mr. France filed on November 22nd, 2021 into the record and have it spread across the record.
Is there any objection? Hearing none, I will admit the described testimony into the record.
Thank you. At this time, I have no further questions and would tender the witness for any cross-examination and commissioner questions.
All right, thank you, Mr. Astrab. Well, since we are here examining a unanimous settlement agreement, there is no need for cross-examination and we will move directly to commissioner questions. And I will begin at this time with Commissioner Duffy if you have any questions for Mr. France.
Thank you, Mr. Chairman. Good morning, Mr. France. How are you?
Good, thanks. Good morning to you.
Yes. I'm noting on page 14 of your testimony, that CURB was strongly opposed to the company's initial proposal to apply its WACC as the carrying charge for the extraordinary costs. And I understand as a result of this settlement, it's been reduced. Tell me, also in the opening statements, it was mentioned there by Attorney Astrab that there are ongoing investigations at the national level and here at the state level. Is that true?
Yes, the Attorney General's office is part of this docket. They're a party, and they lay it out pretty well in their, I think it's their petition to intervene, the statutes that they're looking at, primarily like profiteering during a disaster, those sort of things. And then my understanding is this is also being investigated by FERC. And then beyond that, I'm sure there are probably other either private entities or other governmental agencies perhaps that are investigating. I'm sure in other states, right? So, the Attorney General's office is for Kansas.
Right.
This was a regional disaster. There are many states going through, similar issues to us. So I'm sure it's being investigated in all those states as well, probably in a similar manner.
Okay, so as this docket is coming to a close, or at least there'll be a commission order, will CURB continue to be a part of and aware of the AG's investigation and things that are going on with that?
Yeah, I would hope so. I mean, we certainly would avail ourselves to the AG's office in any way we can. And I know, the commissioners, you all have, I think there was some sort of filing in this docket that basically to the same effect that says, the commission will avail itself in any way available to assist the AG's office. And so certainly, CURB would take that same position.
Okay, so as the investigation continues, let's say that something is discovered where I believe it's understood that refunds, as shared in the opening statements, refunds would go back to the customer. Would that include carrying charges as well? So the 5.31%, I believe, is what the settlement offers. Would carrying charges, are you aware whether that would be a part?
That is a good question. I don't know the answer. I don't believe it's specified. That's all I can say is I don't think it's specified and I'm not exactly sure.
Okay. Let me turn to another area. You represent the residential folks in this state as well as smaller businesses. And have you heard a lot from them since this storm, Uri?
Sort of. I mean, so there are a lot of municipalities and other non-jurisdictional customers. We've had some contact with them. I'll say this. So this docket is in process. A lot of customers jurisdictional customers have not yet been billed. And so I'm not sure that they fully understand the impacts that are coming yet. So I think maybe we'll get more contact from jurisdictional customers once there's an order. We haven't seen a lot of that yet.
So what
we've heard is non-jurisdictional customers, and we sort of, we kind of just direct them back to their own utility, but we do the best we can with that. But jurisdictional customers, not a lot yet.
Okay. So then what would be your plan? Let's say the order goes out, they begin receiving bills in February. What is, and virtually everybody has been impacted in the state. Mr. France, what is CURB's plan as folks begin to see this separate identifiable charge on their bill? What is your agency's plan to help with the understanding of this with customers?
Yeah, so I mean, myself and our attorneys, we're a very small agency. We've all been involved in at least one of these dockets for one of these utilities. So we have a pretty good understanding of what's going on. So we can hopefully, assist and walk the customer through, give an explanation that they can understand. But I mean, beyond that, there are, depending on the customer's income, there's a lot of different options out there. You've got LIHEAP and other resources for assistance with bill payment. So that's usually our number one step, is to say, have you checked with any of these? I think maybe Salvation Army does something. So that's kind of usually our number one step, is have you checked with some of these assistance groups that might be able to help you out or provide something along those lines.
So are you saying that as Black Hills is the first, in essence, followed by Kansas Gas Service and whatever, are you saying that you're going to have an outreach? I mean, are you going to be proactive in reaching out to the customer to help explain what and why this charge is on their bill?
Yeah, we certainly have discussed that internally. I'll be honest with you, we have one of these dockets for every utility.
Sure.
In one of these dockets, at least one of these dockets, we've talked with the utility about, like, basically giving our input on their PR and their press releases and sort of, being involved with their customer outreach directly with CURB. I don't remember if that's Black Hills, to be honest with you. But I know that we've been in contact with at least one or more utilities, trying to get our foot in the door with them directly as far as customer contact. Beyond that, I mean, we have a website, we have a newsletter that we do every few months. So we always try and keep information there. In our newsletters leading up to this, we've had information about these dockets and kind of what to expect. So we try and keep the public apprised. I mean, it's not exciting reading, right? So Joe Public, I don't know that they really paid that much attention to our newsletter, but if you're at least have some sort of base understanding, that kind of thing I think helps. And then obviously, we've got our consumer counsel, David Nickel. He has a lot of contacts and connections, and so I'm sure, particularly once there's an order and once we get a good idea on what the bill impacts will be, I'm sure we'll be active. I mean, David's got connections with the newspapers and stuff, so they'll contact him. I'm sure they'll contact him at some point, and so he'll get the word out that way as well.
Do you think the public generally understands? I mean, they understood this event took place. Do you believe they generally understand that starting in February, there will be this additional identifiable charge on their bill, the Black Hills customer? Do you think they understand that at this point?
To be honest, no. I mean, a lot of people that I've talked to, I tell them that I'm working on stuff from the winter event or whatever. If they ask what I do or how work's going, I say, oh, we're really busy from the winter event. And they say, I don't know what the big deal is. My bill didn't go up that much, And so in my mind, I'm like, well, it's coming. But it's the disconnect and sort of I don't want to be too derogatory, but just, the red tape of procedure and just sort of figuring all this out. Right. So it's, there's not really anything to do about it now, but that is one of my concerns, is what if we don't have these things wrapped up by February of this year, right? I mean, I'm really concerned that there's going to be, there could be another winter event and we haven't even sorted out the first one. But, it is what it is at this stage.
Okay, so just to clarify, you have a newsletter, you're not sure who sees it. And I would agree with you, a lot of times the public, until it hits the pocketbook or it affects them, I mean, right there in front of them, you're right, they're not focused on it. And especially not maybe during this time with so many other things competing for their time and interest, but when they get a bill and the bill's higher than they thought, especially as you look at gas prices and the concern that just the gas price going through will be higher. It appears that what you're telling me is CURB will be working proactively to help the consumer, the customer understand why there is this new charge on their bill.
Yeah, that's correct. And you know, I'll also say that I think it's already been mentioned, you know, this is a multi-phase docket. And in a later phase, we're going to talk about lessons learned and sort of improvements for the future. And I think one of those things that CURB would like to focus on is just customer contact. You know, we've sent some DRs about, you know, do the utilities, are they keeping an up-to-date record of, you know, customer emails and that sort of thing. And so, you know, I think maybe that's something that could be done better next time, is just the contact as things are happening. But again, I mean, that's I don't want to get too much into that because that's not really what this phase is for. But you know, it's certainly something we've been thinking about. And yeah, it's a concern to us, as well as, you know, making sure that the public knows what's going on, because yeah, I mean, it's, you know, if you're getting hit in February with a charge from last February, there's quite a bit of disconnect there between the event and then the end impact.
So I think also, Mr. France, you made a statement, you're a small agency, and all utilities were impacted by this storm. So it sounds like that means there's been an additional workloads on your small agency. Have you all asked for additional funds to help you cope with the business at hand, and so that you have adequate staff to respond to these dockets as they present themselves to you?
I mean, you know, the first thing I'd say is it's not necessarily my call there. I'm not really the budgetary guy, but you know, I kind of know what's going on, and I think to a certain extent we're planning to maybe, or we hope to increase our staff a bit. You know, we obviously there's the logistics of office space, and you know, we might need to expand that as well. But yeah, I mean, I think we're doing okay also. I mean, we're not, it's been a struggle, but it's not been impossible. It's just, you know, it's just, I would say it's part of why this thing has been, to my comment earlier, regarding, you know, we're looking now at a February event. That's part of why it's been so strung out, is because we've got like 8 utilities or something like that we're looking at. And so all these things, and I've you know, I have some experience with KCC staff in the past, and I've never filed 3 testimonies in 2 weeks before. So, you know, it's just, it's easy, but it's manageable. But yeah, I mean, that's, you know, we certainly would like to expand. There's certainly roles that we could fill if we were allowed.
Okay. Thank you, Mr. France and Mr. Chairman. Those are all the questions I have. Thank you.
Okay, thank you, Commissioner Duffy. Commissioner Keen, do you have any questions for this witness?
I have no questions for Mr. France. Thank you.
I also have no questions for Mr. France. On my schedule, it looks like the parties have agreed to allow some follow-up cross-examination of Mr. France. And I will allow that. However, since it is, we do have a unanimous settlement before us. And so I would ask the parties to strictly stay within the scope of follow-up questions within the scope of Commissioner Duffy's lines of questioning. So at this time, I will ask first if Black Hills has any questions for Mr. France.
No questions. Thank you.
Kansas AG's office.
No questions from the Attorney General's office. Thank you.
Thank you. KCC staff, do you have any questions for Mr. France?
No, we do not.
And Curb, do you have any redirect for Mr. France within the scope of Commissioner Duffy's questioning?
Just briefly, if I may. Mr. France, I want to turn your attention to the conversation you had with Commissioner Duffy regarding customer notice, okay?
Sure.
Okay. In regards to the Curb newsletter you mentioned, how often does Curb publish that out to the public in its service list?
We try every 2 to 3 months.
Okay. And do you recall when the last time Curb issued its newsletter?
I think we had a September edition, I think.
Okay. And
Might
would
have been
Curb be able?
October. I'm sorry.
Okay.
I think it was
Okay, no
October.
problem. All right. And considering the time frame for the commission to issue an order in this docket, would Curb be able to include more information about the final outcome of the settlement agreement in its next edition of its newsletter?
Yeah, I mean, like I said, we do this every 2 to 3 months, and we don't really, we try and cover everything that happens within that time frame. So yeah, I'm sure, within a month or two after the order, we'll have something in our newsletter. And I'll also mention, I mean, we have board meetings, and those are our board meetings. We discuss most of our dockets, and they are open to the public. I believe we post notice of those, and a lot of times we have, like AARP will have some people that join in. Again, I mean, it's pretty technical. It's not. I'm not sure it's something that most of the general public would want to sit through, but it is available. And we've talked about these dockets a lot at those meetings. We have one this morning that Joe and I are on.
Oh, that we are. All right, Mr. France, thank you so much. I have no further questions, Chair.
Thanks.
Thank you, Mr. Astrab, and thank you, Mr. France. If there are no further questions for this witness, you may step down virtually.
Thank you.
And we will now move to the second of our witnesses, and I believe that is staff's witness. So at this time, Ms. Bassentine, you may call your witness.
Thank you. And at this time, I would like to call staff witness Justin Grady.
Good morning.
Please raise your right hand. You do solemnly swear the testimony you're about to give and the matter now in hearing will be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
Thank you.
Good morning, Mr. Grady.
Good morning.
Would you please state your full name and your business address for the record?
Sure. My name is Justin T. Grady, and my business address is 1500 Southwest Arrowhead Road, Topeka, Kansas, 66604.
Thank you. And would you please state your title and position at the commission?
Sure. My title is Chief of Revenue Requirements, Cost of Service, and Finance at the KCC.
Thank you. Are you the same Justin Grady who caused to be filed in the docket direct testimony and testimony in support of the settlement agreement on November 22nd of this year?
I am.
And with that, I will tender the witness for commission questions. Thank you.
And do we have a motion to enter Mr. Grady's testimonies into the record?
Oh, excuse me. Yes, I would like to make a motion to enter his testimony into the record.
Any objection? The pre-filed testimony of Justin Grady will be entered into the record. At this time, I believe Mr. Grady has been tendered for commissioner questions. And so I will begin again with Commissioner Duffy, if you have any questions for this witness.
Yes, thank you. And good morning, Mr. Grady.
Good morning, Commissioner.
So as we talk about carrying costs, and the settlement provides for a lesser carrying cost than what the company proposed. And the discussion surrounds that the investment rating is somewhat tied to the to this carrying cost. Can you tell me what the investment rating was of the company prior to Storm Uri and where it is right now. And then if there is an order that approves the carrying costs as proposed in the settlement, what would happen to that investment rating or credit score?
Sure. So, Black Hills is in the favorable and somewhat unique position in Kansas as far as large investor-owned utilities go, in that they actually did not suffer a credit rating downgrade as a result of Winter Storm Uri. So One Gas and Atmos Energy Corp did actually suffer downgrades to various degrees between Moody's and S&P, but Black Hills didn't suffer a downgrade. I think they may have been placed on credit watch negative, but to be honest, I can't recall that specifically right now. But they are an investment grade company, and they did incur a significant amount of purchase gas cost, but relative to their size and relative to the level of costs that One Gas and Atmos incurred, they did not, receive a credit rating downgrade. The reason that there's discussion in my testimony and you heard discussion in the opening statements regarding the tying of the carrying charges to the maintenance of the investment grade credit rating is because that's critically important for us from staff's perspective. And I know it's important to the company, but it's important because ultimately customers pay those costs of borrowing, right? So when a utility company gets downgraded, that's not a theoretical or philosophical type of a concern. That's a real world dollars and cents concern that ultimately affects ratepayers because the cost of capital is reflected in customers' rates. And so, the company's original position was weighted average cost of capital is appropriate for us for, stretching out the recovery period over this long, 5 years. Mr. Daniel could correct me, but I believe a 5-year recovery period is the longest recovery plan that the company has for all of its Winter Storm Uri costs across its multiple states that it serves. So, the maintenance of the investment grade credit rating was important to us in the negotiations and our discussions during this case. And so ultimately the carrying charge that was agreed to was reflective of the actual capital costs that the company incurred in terms of additional debt load to pay off these costs originally. And then a recognition of the fact that those debt costs are only possible if there's a certain amount of equity that backs up those debt costs, and there's a reasonable plan to return the capital structure and the credit metrics of the company, back to a reasonable level over the period of the recovery. And so, those are the factors, those are the considerations that went into the parties, negotiations when it came to identifying the carrying charges that are in the agreement. And that's why indirectly, if nothing else, the company's credit rating is tied to the carrying charge.
So as we will be dealing with this with other utilities, will all of them be taking advantage of carrying costs as the way to pay, or is there something else in the toolbox that other companies might use that Black Hills is not?
So we did file a settlement recently with Kansas Gas Service, and their plan is to request commission approval of a securitization plan to pay for these charges. Atmos has a plan that is pending before the commission right now. We haven't actually completed our review of that plan. It's further along the pipeline. They were we've done our best to address these plans chronologically as they come in, and Atmos is later on this year into early next year. But I believe their request is also tied to the use of securitization. So there are other tools in the tool chest, but there's pluses and minuses and pros and cons with each approach. But securitization generally has a much lower carrying charge, but would have higher upfront costs and a longer period of time of implementation typically. And there's and the recovery of those costs can't begin for a while also. KGS's current estimate is that if the commission approves the use of securitized bonds to finance these charges, those bonds won't be issued until February of 2023. So it's, that needs to be considered as well. And it's really just I don't know, it's sort of a policy call and a case-by-case situation as to whether or not securitization works for each company.
So apparently securitization was not offered by the company, but in your opinion, was this an option to be considered? And if not, why?
So the one important thing about securitization is that in every state in the country that I'm aware of, and this information would be updated through last legislative session, because I spent a lot of time working on the securitization legislation that passed last year, and so I was very familiar with every state's legislative solution or statute regarding securitization. And so with one exception in the country, and that's the state of Texas, securitizations are always voluntary on the part of the utility. And I think there's securitization legislation in, I think, 23 states, and our legislation is that way as well. So, basically that's a decision that the utility and its management discretion has to make. In other words, if we can't force them to use securitization, even if we think it's a really good idea. So that's just an important backdrop or context, I think. But in this case, the company performed an analysis that said, look, with the higher upfront costs, given the size of the company, given the amount of capital that was going to be securitized in Kansas, and given the fact that Kansas was the worst hit of all of Black Hills's territories. And so, in other words, the amount wasn't quite at the level of materiality that Black Hills thought made economic sense for its company to do a securitization in Kansas. And while the company incurred extraordinary costs in Arkansas and Iowa and Nebraska, on a per capita basis, those impacts weren't as bad in those states. And importantly, they don't serve in Texas or Oklahoma, which were much worse hit than Kansas generally with regard to natural gas issues and costs. So there's sort of it's a multifaceted, there's a variety of reasons why I think it didn't make sense for Black Hills. And I didn't agree. I didn't disagree with the decision that they made that securitization, might not work best for them in Kansas. But I went into the background that I did because even if I had disagreed, there might not have been anything we could do about it.
Okay, thank you. My next question, as I look at the signatories to the agreement, I don't see the Attorney General listed. Can you share why they aren't, and just generally, from your standpoint, discuss their involvement?
Sure. I can't share specifically why they're not a signatory because I'm not personally aware of why they're not a signatory or signator. I know that a representative from the Attorney General's office was involved in I would say nearly all of, if not every meeting that we had in this case, and I'm just hedging there to be careful because I'm under oath. I mean, if I had to guess, I'd say they were in every single meeting that we had. I certainly recall that Melanie or Miss Jack was a participant in those meetings. As to, what their involvement in this case and their participation, I know that Ms. Pemberton, our Chief Litigation Counsel, has been in regular contact with their office. The commission ordered us to share all of our discovery with them and share all of the documents that are in our possession, and we certainly have complied with that. So I think that their involvement and their participation is mainly going to be a civil matter in the court systems. I say a civil matter. It's going to be in the court systems and not necessarily before the KCC. That's my understanding or my impression. But as far as this proceeding goes, they were involved every time we had a meeting, and my understanding is they don't oppose the settlement, and so that. But I think that's the extent of my knowledge about their position in this case.
Okay, just to follow up, you mentioned Ms. Pemberton. So while you're maybe not involved directly in their investigation, which they announced and are proceeding through their statutory assignments, you believe Ms. Pemberton is involved as they continue their investigatory efforts?
Yeah, I think what I would say is I don't know the degree to which she's involved. I just know that, I hear sort of secondhand that they've had communication. I just know that, and really just for a little follow-up, I think the primary reason for that is, we're technical staff. And so there are, there's rules pertaining to discussions of technical staff or non-attorneys with other attorneys. And so that's just the ordinary course of business is that, they're primarily attorneys over there. And so attorneys talk to attorneys sort of, I haven't been involved, and to be honest, I don't have direct knowledge as to how involved Ms. Pemberton has been, but I think it's primarily just information sharing and participating or conforming to the commission's order to share information.
Okay, thank you. Since you've described yourself as technical staff, let's get into a little bit deeper detail. Say I'm a customer of Black Hills, and in February, under this settlement agreement, I get my bill, and it will have a separate line item that identifies the cost as a result of Storm Uri and whatever the commission decides. Tell me, how do they arrive at that cost per customer? Was it based on those few days or their average expenditure or usage rather of gas throughout the year? How is that determined per customer?
Sure. So the charge that's called for in the settlement is it's a volumetric rate per therm of gas usage. by customer class. So it's a different rate by customer class. And that rate was derived by spreading the extraordinary costs that are in the cost recovery plan across the different customer classes based on how that class used natural gas during February of 2021. So it's not, so I don't have the settlement agreement printed off before me, but I can minimize this Zoom window and go find it. But I think for residential customers, isn't it like 78% of the charge? Mr. Daniel can probably correct me or use sign language or something to put the actual percentage up in the window. But each customer class, the way that their usage contributed, the way that each customer contributed to the total system usage in February of 2021 dictated the percentage of costs of extraordinary costs that they are paying under this recovery plan. And then it's basically a rate design question after that. And it's just divided by the typical annual consumption of that class, so that it's a volumetric rate. And so if the commission approves this agreement, come February of 2022, a regular residential customer would see a charge on their bill that says Winter Storm Uri, Winter Storm Uri cost recovery or recovery charge. And that'll be a volumetric rate based on the gas use that a customer uses for the next 5 years, right? So from February of 2022 to January 31st of 2027. Oh, Commissioner, you're
All
on.
right, so what you're telling me is that it will self-adjust through the years, correct? The volumetric rate?
The volumetric rate itself is fixed.
That's fixed, but per the customer's usage.
Right. So the rate itself is fixed, but we do have a true-up mechanism because it's based on volumes that are used. And so that's always the case, right? It's to a certain degree, it's sort of like predicting the future of what's a likely amount that customers will use over the next year. And if it's an exceptionally warm winter, actually like this winter so far, right, volumes are down quite a bit. And so that charge will adjust up or down each year, but it will be fixed for a year. And then with the goal at the end of the 5 years being that customers pay for the extraordinary winter weather costs, no more, no less.
Will every utility use this methodology, or is this, again, there are different tools in the toolbox as it relates to what the customer's charges?
So they all are quite different. I'm involved in the review and investigation of all of them. So I probably can, recall the details of most, but I'll just try to go through a few just real quick. So Southern Pioneer, for instance, is an electric company owned by a cooperative in Southwest Kansas. They serve, actually, Mr. Cairo, one of his clients, National Beef, is an electric customer of Southern Pioneer. For instance, they have requested a little different plan in that they're actually tracking the costs and the responsibility for these extraordinary electric charges during February of 2021 on a per customer basis. So they're set up differently. They're owned by a cooperative, and so they track capital credits, and those customers basically own their utilities. So they're different. They're set up a little differently, and and it's more of a debt or an individual obligation for that company. That's still pending before the commission. It's high on my priority list to get that written up and recommended what staff's position is on that pending docket. But both KGS and Atmos have requested to use securitization. If that's approved, the securitization charge itself will be fixed with either fixed or variable with a true up, but the true up is very limited and is required to be very limited pursuant to the securitization statute. So it can only be trued up or down as necessary to ensure that the company has the cash flow and the revenues to pay the bonds and service the bonds on time. So, that a securitization is different, and those details, there's a lot of required factors that the commission has to rule on pursuant to that statute that will be back before the commission if the commission approves the plan, which is to use securitization. The commission approved a small gas utilities plan, American Energies. They serve about 200 customers in central Kansas, the Mack County area. They actually also tracked the costs on a customer by customer basis. They were able to do that because they're small, and those costs were tracked based on February usage per customer. So yeah, they're all a little different.
Okay, one more question. Let's say I just moved into the Black Hills territory this month. So, and I moved from California. So will I have a separate line item on my bill?
Yes.
Okay, so I will become a payee into Storm Uri.
Yes, that's correct. It's.
What if I move from Kansas Gas Service to Black Hills? Am I responsible?
You still would be, yes. So, there's a few provisions in the settlement agreement to address sort of unique one-off customer concerns. And so if you were a transportation customer and you were responsible for buying all of your own gas, you likely received a bill from your marketer already for the entirety of the expense, and you either paid that or they're suing you, whatever the case may be. But as we've found in some of the other proceedings, the commission has relatively limited jurisdiction over and ability to protect transportation customers. Those customers are sort of out there on their own. They many of them received, bills that are well in excess of a year's worth of gas all at once. And so we worked into the settlement agreement protections for transportation customers that have likely already incurred and paid their costs. There's also protections in the agreement for if you were a utility customer in Kansas and you've already paid your winter weather costs. Let's say you were a customer of American Energies, or you were a customer of a municipality, or Kansas Power Pool, or you're a customer of a municipality that's part of Kansas Municipal Energy Agency, and therefore you've already paid for your portion of winter weather costs, gas costs, then there's a provision in the settlement agreement that would allow that customer to request a waiver from the Winter Storm Uri costs. And so, those weren't, Black Hills can tell you those are not very common provisions across their service territory. They're burdensome from the company's perspective. Not overtly burdensome, but there's additional manual labor that's required in order to make those happen, and there are some costs associated with that. But that was an important provision of the agreement from our perspective to make sure that if there were those unusual circumstances where a customer, you can only imagine if you put yourself in that customer's perspective. And I was a customer of a local municipality, and I already paid that municipality $800, and now I'm being asked to pay $11 a month for 5 years. That would be inequitable. And so we've made provisions to protect from those instances. But I guess part of the unfortunate reality of socializing costs like this over the entirety of the customer base and spreading out the impact of costs like this over a 5-year period of time, it's better from a customer's perspective because they didn't face one giant bill up front or over a year. But part of that unfortunate reality when you socialize those costs is that there will be people who I'm sure move to the Southwest Kansas area or the Lawrence area in Black Hills Service Territory, and they came from Wisconsin or California, and they weren't a customer. They didn't incur those costs directly, but they're helping to pay for those costs over the next 5 years. And I guess the way that I personally got comfortable with that reality, for me, and I know it's not directly relevant, but for me, I look at a situation of after a natural disaster, like a tornado or an ice storm. If I moved right now to Joplin, Missouri, and I started paying Empire District Electric Company rates, I'm sure that my bill would be higher because of the devastating tornado that they incurred when an F5 tornado took out a large portion of their system. And somebody might argue that that's unfair or that's unreasonable because I wasn't a customer during that period of time. And why am I having to pay to help rebuild the system? So, there may be criticisms of that analogy, but for me, it's appropriate. I think it's really the same type of a situation. That's a natural disaster and a physical disaster, and this is a financial disaster that affected, every utility in the Midwest. And so, I don't know to what extent that helps, but that's my thoughts around that issue.
Thank you. I do appreciate you clarifying that. Let's move to a different area. It was mentioned earlier that the commission meets yearly, basically in the summer, with each gas company to talk about their plans for the upcoming winter season. And as this event occurred with just basically 2 months left in the winter season, I understand that whatever agreements had been met, had been realized with that company, were on the tail end. But let's talk about the conversation that you had with the company this past summer. How did that conversation, how was that different from the year before?
Yeah, so for a variety of reasons, mainly just the fact that the natural gas market is so competitive and entirely or nearly entirely deregulated, and it's a highly competitive market. The specifics of those conversations are the commission has long recognized that those conversations should be confidential, or the details. But I'll talk just generally about it. And we during the last year, there's since February, there's been a lot of work going on, obviously, at the commission pertaining to Winter Storm Uri. And for me personally, and Josh, Mr. France spoke about this some, but if I were to give my absolute best guess, I would say that 80% of my time since February 17th has been spent on Winter Storm Uri issues in one form or fashion or another. And I don't see, and close to 100% of my time will be spent on that from now until January 11th, when I'm scheduled to present before the Senate Utilities Committee on this issue. Maybe even over 100% of my time, right? But this is a hugely important issue, and when we started meeting with the gas utilities, the timing of those meetings is sort of odd. I mean, in that they're all over the board. So we meet with some of those gas utilities like in March or April, right after the winter. And then we meet with some of them in June, and we meet with some of them right before the winter season. But in any case, all three of the major gas utilities in the state of Kansas, we had between 3 or 4 meetings with them, extensive technical discussions, virtual all, but pertaining to their gas purchase plans for this upcoming winter. And, the primary overarching theme of those discussions, in addition to just what we're required to discuss from my perspective, was what can we do? What can the utilities do within the bounds of existing commission authority and commission approved budgets? What can we do to try to prevent or mitigate as best we can the recurrence of an event like this occurring again, if God forbid this were to occur again this upcoming winter, right? And the gas utilities, I mean, all three of them are different, and they're all different. They take service on different pipelines. They have different suppliers. They have different strategies, serve different areas of the states. It's kind of amazing, honestly, how different the three utilities are in this regard. But for Black Hills in particular, that they have now filed that plan. I would, recommend or encourage you to take a look at it if you haven't already. I think our response to that, or our view of it, will be filed I thought it was filed last week. It'll be filed yesterday, today, tomorrow, something like that. But the Black Hills has taken steps to mitigate the recurrence of another winter weather event like this, or at least the financial impact of that for this upcoming winter, and as has Kansas Gas Service and Atmos Energy Corp. Now, and the details of the three of them are different, like I mentioned. And the one thing that I need to stress, though, is that if there were to be an event, like for Black Hills in particular, if there were to be an event in which the cost of gas on the daily physical gas market in Kansas were to increase, 100 or 200 times the normal, Black Hills would not be completely insulated from those financial impacts for this upcoming winter, and the other two gas utilities likely would not be either. That's the unfortunate reality of the natural gas market, and the way that these gas utilities plan and purchase gas for their systems, and the fact that you can't predict precisely how much gas you're going to need for any one individual day a year in advance. And so you're, at least in my view, I don't see how the gas utilities can get outside of being exposed in one form or fashion or another to the realities of the daily physical gas market. But that doesn't mean that, we're not trying, and we're not thinking about it all the time. So our efforts to date have mostly been about, for this upcoming winter, within the bounds of your existing commission-approved hedging program, what can we do to mitigate or prevent the recurrence of the event? But going forward, those conversations aren't over. All three of the gas utilities know that we have a strong interest in continuing to think about this and to try to do everything we can to get better going forward. And so whether that's additional storage contracts or expanding the use of storage, whether that's increasing the hedging budget or the hedging practices of the utilities or the contracting strategies, the unfortunate reality of all of those things is that every one of those volatility mitigating factors will cost customers more money, right? And so to a large degree, this is a longer term question of what are we willing to pay in this state every month in order to prevent the recurrence of a winter weather event in which we might incur 5 years worth of gas costs in a week, and so these are big, lofty policy questions that aren't going to be easy to answer, and they're not going to be answered by this winter. But we're going to continue to think about them and talk about them, and eventually we're going to file our recommendations in this docket before the commission, and we're all going to have an opportunity to try to figure out that balance and the proper solution together.
Thank you, Mr. Grady, and you're leading me right to my last question for you. So while we will issue an order on this particular issue, staff is going to come forward in this docket, is my understanding, and every docket with recommendations going forward. We're not at that point, but is it correct this docket will remain open and you will all share lessons learned going forward with recommendations so that we can discuss, just like you said, how far do we go to protect customers for that one-time event that, who knows when that will be. It could be this winter, it couldn't maybe it won't happen for a decade. But is that correct? You will be coming forward in the next few months with your recommendations.
That's correct. Yeah, our plan is to file individual company-specific reports that detail the extent of our investigation and what our findings have been, and probably will be along the lines of preliminary or initial recommendations. And the only reason I caveat it like that is because, these are, we may likely recommend that, for instance, Black Hills evaluate the economic feasibility and the physical reality of pursuing additional storage options on its natural gas distribution system. But that's going to come with a big question of economic feasibility and physical availability of that storage. And so, but it'll start the conversation. And then the idea is, one of the ideas I've thought about is, it may be time for the commission to reevaluate and to reinitiate customer focus group discussions. The hedging plans and the gas purchase plans that the commission operates under right now. The last time we took a really heavy, close look at that, a multi-year type of an effort, was around the 2001 timeframe. And so the budgets were set based on those customer focus group discussions and the purchasing plans and the hedging plans. And so, as an industry collectively, maybe and as the commission, maybe it's time to reevaluate that. With Winter Storm Uri having affected all of us, and it's certainly shaken me and my view and my risk tolerance and what the gas utilities should be exposed to with regard to gas volatility and the volatility of natural gas charges. So anyway, so those are some of my ideas and thoughts, and yeah, we're going to formalize those and reduce those to writing just as soon as we have the opportunity.
I would agree with you that if it's been 20 years since we've looked at the PPA structure, so much has changed since then, and technology has changed, and technology can be a real assist in particular with the energy companies. I mean, it's out there to be used. And you're right, we need to think more broadly and reevaluate. I would be remiss if I did not ask you this. With the company's PPA that was in place for that you met in the summer of 2020, that started that fall into winter, did Black Hills, did they operate within the scope of what had been agreed to?
They did. Just a quick clarification on, the general structure and the budgets that were set to set the hedging programs were set back in that 2002 to 2005 timeframe. But, the plan itself, it's not like it was we set the plan 20 years ago and then nobody's really looked at it since then, right? It's annually reviewed to account for changes in customer demand patterns, changes in supply availability, interstate gas pipeline construction, or new capacity addition points or supply points. It's a pretty sophisticated analysis. It's interesting that a lot has changed in 20 years, but based on the review that I've done recently, not a lot has changed in the natural gas market. And I mean, a lot has changed with regard to the underlying fundamentals and gas supply and demand. And obviously the shale revolution was a major fundamental change, a tectonic type change in the natural gas market. But I mean, the gas day and the provisions of the contracts and a lot of those things are still the same, and so I don't know, everything's on the table from our perspective in terms of what needs to be looked at and evaluated going forward to try to mitigate volatility and produce as much certainty as possible for customers. But again, the thing to keep in mind is, I mean, if there's an exception to this, I haven't found it, in that every single one of the solutions that we can look at, whether it be more fixed price contracts, if you set a fixed price of $5 or $6 for several years, then that might be great if gas goes to 10, but everybody questions your decision making if gas goes to 3. If we look at additional reservation fees or changes in your contracting strategy for your purchase gas contracts, those come with real charges, sometimes $1, $2 a decatherm in terms of reservation fees that you have to pay every day, regardless whether you use those contract strategies or not. Storage is not cheap. It's not free. So, this is the big question. It's a collective. A lot of people are going to have to put their minds together and think about what amount of risk are we collectively willing to take going forward, and what amount of cost are we collectively willing to pay in order to every day, every year, in order to prevent the potential of that risk and of that event at some point in the future, which is unknown exactly when it's going to occur. So big questions for sure.
Thank you, Mr. Grady. Also, I would just throw in there that as we look at our energy efficiency programs, those we need to be looking at them to make sure that we're giving the best tools in the toolbox to our customers throughout the state, regardless of the utility, to see what they can do on their end to better secure their home. Just anecdotal, my daughter and her husband living in Sheboygan, where they're full into winter right now. I have never been in a tighter house where they're running around inside with their steam heat and in sleeveless shirts and shorts, and there's no wind blowing through these windows. It's nice and toasty inside, and it's common in that neighborhood where they live, that this is how you do winter in Sheboygan. And I think perhaps the folks in Kansas have a lot to learn, or at least I know we do at our household. So thank you, Mr. Grady, for answering all of those. And Mr. Chairman, I am finished. I appreciate the
Thank you for
opportunity.
the questions.
Thank you, Commissioner Duffy. I suspect there may be a few more commissioner questions based on some of that. And there may be some follow-up questions. We've been going for a little over 2 hours now. So I think what I will do is give everyone maybe a 5-minute break, and then we will come back and try to wrap up before lunchtime. So at this time, we will stand in recess. We are off the record, and we will return at 11:18. All right, I have 11:18 on my clock. I see Dwight has rejoined us. Commissioner Duffy, can you confirm that you've rejoined? Okay, gotcha. And Mr. Grady, I see you. All right. If the court reporter is ready, we are now back on the record in the evidentiary hearing coming out of recess. And thank you, Mr. Grady, for giving us the opportunity for a break. I hate to pause in the middle of a witness, but I know you can handle it. So at this time, I will ask Commissioner Keen, do you have any questions for Mr. Grady?
Thank you, Mr. Chair. Good morning, Justin.
Hey, good morning, Commissioner.
Justin, I have reviewed your pre-filed testimony. I've listened this morning to your testimony. And to me, I think that collectively evidences several things. It evidences to me a thoroughness, a detailed, fact-specific, comprehensive investigation of the Winter Storm Uri by our commission staff from the perspective of the impact that that event had on Black Hills and its customers. At the outset, I want to commend you and your staff for this professional and obviously exhaustive effort, which I realize is ongoing. That's because no good deed goes unpunished, Justin. What I want to do this morning is somewhat holistically take a look at and sort of summarize your testimony as I understand it. And then I have a couple of questions that I'd like to propound after I do that. So bear with me. It won't take but just a short time. As I read your testimony, it reaches several important conclusions. Based upon the staff's review of the customer plan that Black Hills has filed in the docket, it's my understanding that the staff believes that it's a reasonable and a balanced plan that appropriately minimizes the financial impacts to customers of these extraordinary gas costs incurred during Winter Storm Uri, while simultaneously maintaining the financial integrity of Black Hills and to allow Black Hills to recover its necessary carrying costs associated with these extraordinary costs incidental to that event. I think the plan also, your conclusion, I believe, is that it allows customers to pay the extraordinary costs associated with the Winter Storm Uri over a 5-year period, essentially from February 1st, 2022 through January 31st, 2027. You acknowledge, and I think it's important that you do this, that these charges are certain to be a hardship on many Black Hills customers. However, I think it's your conclusion that it's less of a hardship than it would have been to pay these charges through the ordinary course of business, which would have called for paying for these costs over a 1-year period beginning in November of 2021. Your testimony also reviews various spill impacts. That's contained within your testimony. I'm not going to repeat those. Your testimony, I think, recognizes that the plan presented by Black Hills acknowledges, obviously, that there are real costs associated with allowing customers to pay off balances over this 5-year period. And accordingly, the plan allows for the recovery of these carrying costs. In that regard, I think your testimony indicates that while Black Hills' original plan was in compliance with the Commission's emergency order, the plan was modified as a result of the settlement agreement to contain carrying costs of 1.3% for calendar year 2021 and 5.71% for the period 2022 through 2027. As a result, and I think this is not inconsequential, this reduction in carrying costs resulted in a $7 million reduction of carrying charges in Black Hills' original proposal from a little over 20 million, almost 21 million, down to, if you say down to, roughly 14 million. In addition, I think your testimony indicates that based upon the staff's review of the reasonableness and prudence of Black Hills purchase gas costs incurred during this winter storm, the staff's review indicates that Black Hills gas purchases during this February 2021 event were consistent with the gas purchase and hedging plans that the utility had on file and has been filing on an annual basis. Now, these are some of the general conclusions I think that I have derived from your testimony. Am I correct in that? And to the extent that I've stated some portion of your conclusions, have I stated any of those incorrectly?
No, sir. No, you haven't.
Here's the question for you. What I'm really concerned about, what I know we're all concerned about, what I know you're certainly concerned about, is impact upon ratepayers. And so my question is this: from the ratepayers' perspective, what, in your opinion, are the most compelling and beneficial aspects of the settlement agreement?
So, my perspective is from a ratepayer perspective, what I am most, I guess, the proudest of with this particular agreement, and you know, and also the other plans that we've been able to put before the commission to date, which would be the American Energy's plan and the city of Eskridge, is just it's just customer affordability and the ability to spread these costs out over a reasonable period of time, so that the individual customer impact isn't you know, devastating or too unaffordable. I mean, this is an event that affected every utility in the central part of the United States, right? And to each of them somewhat differently. But if you're a gas utility that purchases gas on behalf of your customers and then distributes that gas to them in Kansas, Colorado, Oklahoma, Texas, Arkansas, Iowa, or Nebraska, then this event affected you significantly. And from a regulator's perspective, it's frustrating and unfortunate in that, you know, there's only so much we can do. I mean, you know, we reviewed and are still reviewing these plans and the actions of the gas utility to ensure that they were consistent with what they were supposed to be doing. But to the extent that the utilities behaved consistent with their plan and they just were caught up in truly an unprecedented once in a lifetime type of a market event, then there is, you know, then at that point, our focus and attention turned to, we've got to get these monthly bill impacts down to a level that's not going to be a true hardship for customers. And how are we going to do that? And that's what a lot of our time has been spent doing. You know, we had, I mean, this goes to a different company, but American Energy's gas service, you know, they're a very small utility. They incurred a very significant amount of gas on behalf of their customers. You know, originally they were looking at a 3-year payoff plan, but that was too expensive. And so we did everything we could to work with them to get external supplemental financing to turn it into a 5-year plan. You know, Black Hills has some 3-year recovery plans in Nebraska and Iowa, I believe, but it would be too expensive to do that over a 3-year period of time in Kansas. And so I don't know. That's the aspect of it that's most compelling to me. And And I'm not sure how appropriate this is, but just from a sort of a personal perspective, you know, I spent 20 years in Dodge City. I was born and went to high school there. And I still have a lot of friends and family there. My stepdad is the ex CEO of a manufacturing business in Southwest Kansas. And they have two facilities, one that is served by Black Hills as a sales customer, and one that's a transportation customer 50 miles away. And so, you know, I'm aware of the details of the bill that he received for the facility that's a transportation customer. And it was unbelievable. You know, it was thousands and thousands of dollars all at once. And they have not received a bill yet for their facility that's served by Black Hills. It's a sales customer. And I've had personal conversations with him about the fact that I know he will appreciate the ability to pay off those charges over the next 5 years in a predictable and consistent and, understandable bill impact. And that we've all heard the stories of a small greenhouse or a small manufacturing facility that received a bill that was multiple times an annual normal gas cost. Municipalities and a lot of those entities would have appreciated the stability and predictability and the ability to have a payment plan over a 4 or 5 year period of time with relatively low financing costs. So I guess from my perspective, that's the most compelling aspect of it, is just that, as unfortunate as it is, and I don't have a magic bullet to say, that the gas utility should eat these costs or that they were imprudent or, the customers don't have to pay for them, because I don't think there's anything they could have done to avoid them. And if I could come up with something that they could have done to avoid it, then that would be impermissible hindsight, regulation that would be overturned by the courts. And so I would just say, I think we've done the best we can. We've done everything we can. And I hope customers understand that. I mean, I have told customers that are my friends and family that will be paying these charges. That's what I've told them. That's how I try to sell it to them. And so from that perspective, that's all I can do.
I appreciate that response. Your answers to questions are always somewhat granular, and they're always first rate, and that was no exception. I appreciate the candor of your response, Justin. There's just anecdotally would add, almost inferentially here. There's one problem with 100-year or so-called 100-year or 500-year events. The problem is that the next day that begins the next 100-year cycle or the next 500-year cycle is the day after that event. So there's no assurance that you're going to wait any protracted period to have a recurrence of that. And I know that we're all sensitive to that being the fact, such that we're concerned that as far as we can, certainly as regulators, take whatever steps we can to see that we don't have recurrences of these events. They're very problematic. Their effect is so devastating across the board in so many ways. My final question to you is this, Justin. And I'm going to allude back to the PowerPoints that were included within Mr. Flaherty's presentation. I would commend all of our attorneys here that are appearing on behalf of their clients for an excellent opening statements, especially in a case of yours, Jim. I thought that your PowerPoints were really quite effective in conveying the point that you were trying to make on behalf of the company. But let's go back to the one aspect of that I think in terms of ratepayer effect, that's most important to the ratepayers. We have, as everybody's already acknowledged, a number of investigations that are pending, a number of lawsuits that are pending, all having to do with the question of whether or not the price for natural gas paid during this basically 1 week period was appropriate, or whether there were other influences here that may cause there to be either profit disgorgements. There may be some civil suit relief. There may be some market manipulation payments. We have various attorneys general across the, certainly across this time zone that are involved, including our own. And I think, as was alluded to, I know FERC has their investigation underway as well. In the event that there is any form of recovery by Black Hills as a result of any of these types of inquiries, whether it's litigation or regulatory action or whatever, is there some certainty to the customers here in the case of Black Hills that there would be a pass-through of all such payments to customers?
Yeah, I'd say that customers should believe that there's absolute certainty that that's the case, right? The settlement agreement is a binding contractual agreement that that this company is now, if the commission approves that agreement, the company will be bound by the force of law, essentially, to capture, track, and give back any proceeds that would come from any of those efforts that you described. And so, what I would say with regard to the mechanics or the mechanism for that occurring is this, in that this alludes to Commissioner Duffy's earlier questions of carrying charges. So you have to go through some hypotheticals and think about, well, what happens if the proceeds were to be 6 months from now or 12 months from now? If the proceeds from some sort of civil suit relief or profit disgorgement occurred during the period of time of the payoff, then there's certainly a way to capture the mitigation of carrying charges that are associated with that, right? So you could just credit those proceeds back against the asset balance and then recalculate what the payment plan would be. You could, and then we would submit that for commission approval. You could also set it up to where, let's just say that the proceeds were received in year 2 out of a 5-year payment plan. Well, you could set it up to where the proceeds would be given back to customers over the remaining 3 years of the 5-year plan, with carrying charges that accumulate to customers, such that the end result is the exact same as if you had just never charged customers in the plan that's before you right now. So I would say that the agreement has that kind of flexibility. But what's absolutely certain, and customers should take this to heart, is that if there are any proceeds from any of those investigations, that Black Hills will be required to refund or return that money to the customers that paid these gas costs.
Very well. Thank you very much, Justin, for your testimony and for your work. I have no further questions.
Thank you.
Thank you, Commissioner Keen. I have just a few questions for you, Justin, and these will be easy for you, I promise. They are more in the nature of most of them are in the nature of clarifying, the record and my understanding of how this is working. Just a first basic question. I believe the settlement agreement describes $87.9 million of extraordinary costs, and then it separately describes $13.7 million of carrying costs or projected or expected carrying costs over the 5-year period. Just for clarity, that 13.7 is on top of the 87.9. It is not the 87.9 is not inclusive of the carrying costs, correct?
That's correct.
So as a total projected figure, we are talking about a number just very slightly north of $100 million that would be recovered from customers, correct?
Yes, that's correct.
Okay.
That's my understanding. I mean, I'm nearly certain of that because the gas costs themselves are 87.9 million. So yeah, I'm not looking at that schedule in front of me, but yeah, that's accurate.
Okay, that was my understanding. Just wanted to clarify it for the record. And then I think you just cleared this up for me. The $13.7 million of carrying costs to be recovered. That is essentially a projected figure of what we would expect those carrying costs to be. But to the extent the extraordinary costs were reduced before the end of the 5-year period, the actual carrying costs might actually be less than that, correct?
That's correct as well. Yeah.
Okay. Now, I think Commissioner Duffy asked you a bit about the true-up mechanism, and I'm sure this is laid out specifically, but I didn't specifically see it in the settlement. Just wanted to confirm that, at the end of that 5-year period, as you said, you're never going to hit that number exactly on the mark. And so there is an additional year true up, I guess the 6th year, where you would true up what the final over or under recovery is. Is that correct?
My recollection is that the final true up would occur through the PGA or through the ACA. And if that's not specified in the agreement, then that would be my intent as to how to deal with it, because we're going to be recalculating that true up on an annual basis. By the time you get to the end of the 5th year, it won't be, a significant material amount, or it shouldn't be. It should only be the difference between the projected volumes billed to customers in the 5th year versus the actual volumes, and it's over an entire year. So, a 10% variation in billing volumes for a year would be enormous, right? So it's likely to be less than that. So my take would be to just, whatever the remaining under over recovery is, just make a debit or credit in the actual cost adjustment portion of the PGA, and just allow it to be recovered like that over the following year.
Okay. New topic. I know in this settlement, we are covering both the financial plan and the waiver of penalties for third parties on the system. And it's my understanding from reading the testimony that Black Hills is somewhat unique in that they did not incur extra incremental gas costs to cover unexpected or overage usage from their transportation customers. Can you maybe just give very high level color of why that is? Why were they uniquely situated from other utilities in the state within that respect?
Certainly. So what I would say is uniquely situated might be just slightly too strong of a description for Black Hills, but they are differently situated than Kansas Gas Service, or at least in my view they are. And so, we beginning shortly after the winter weather event, we were in very frequent communications with all the gas utilities in the state, and Black Hills is certainly no different in that, the question of potential penalties to transportation customers came up and was a big topic, right? It was something we were quite concerned about. We were concerned about the potential economic impact to the transportation customers if they were to receive, significant or, devastating penalties. We were concerned about the sales customers, if those penalty provisions of the transportation tariffs weren't utilized to make sales customers whole. And that's just because the way these purchase gas cost adjustment mechanisms work is basically sales customers pay for everything that transportation customers don't pay for. They're kind of the balancing account in those PGAs. And so, for the first month and a half or 2 months, to be honest with you, there was information. People had such limited or incomplete information. Utility companies were still receiving bills from their suppliers. They were still working through interstate pipeline statements. There were penalty waivers that were pending at FERC, and it was, it wasn't a clear situation for a while. But as soon as Black Hills sort of came up for air, the very first meeting I had with them, in which they actually had some information and we could all have a reasonable conversation, that their response was, we did not purchase gas on behalf of transportation customers or marketers that were short on our system. All right. They just said, to the extent that there were shortages, we leaned on the interstate pipelines and or our short-term balancing services or our short-term storage efforts or our storage contracts, and that's how they handled their shortages. Now, what that did was expose Black Hills to some potentially very significant penalties on the interstate gas pipeline system, right? And they take service from quite a few pipelines. They're not quite as exposed to one individual interstate pipeline like some of the other gas utilities in the state. And that's just due to the geographic dispersion of their territory. If you look at it, think about it, right? They serve Dodge City, Garden City, and Lawrence and Goodland, So, but in any case, they were heavily exposed on some of those interstate pipelines to penalties and storage overrun penalties. And from the very beginning, their conversations to me and others were, the provisions of our tariff are very specific that if we incur those penalties, we will pass them through to the transportation customers that cause them. And so, it's amazing that even in this one this one narrow area, the provisions of these three gas utilities tariffs are quite different. And if you look at the penalty provisions and the daily balancing requirements of Black Hills tariff, it's quite different than KGS. But in any case, there is that specific stark, warning or language in the Black Hills tariff that says, if we incur penalties, associated with daily balancing requirements, we will pass those through on to our transportation customers or our customers. And so, that's what they did. And you could say that they took a risk in that regard, but it worked out because all of those penalties were waived, and they did not incur those charges. So everything that I have reviewed and evaluated through the course of this investigation has validated that original message that they had to us, which is, we did not incur purchase gas costs on behalf of our transportation customers. So that's why the permanent waiver is part of the settlement agreement.
That's really helpful context. Thank you. The only final thing, and this one maybe is not as easy of a question, but it's something I want you to just briefly, I guess, pontificate on or give me how you weigh the factors, is the issue of the repayment period. I know for this settlement agreement, it's being proposed to recover costs over a 5-year period. And the monthly bill impact, at least for residential customers, is not insignificant. It's a material amount. I know other utilities have talked about 5, 7, 10-year periods. You can confirm this for me if you've heard it as well, but I've heard in other states they're proposing repayments over as long a period as 28 years, which sounds incredible to me. I guess what I would like from you is, could you just briefly weigh in on what are the considerations that a regulator should think of when considering these different repayment periods? Obviously, you can get it to be a very small charge if you go out over 28 years, but what are the pros and cons we should be thinking of? What did you think of, and you hit on this a little bit, but what did you think of when you weighed things and landed on 5 years with Black Hills specifically?
No, thanks for the opportunity to go into that. Because, if I'm being honest, I might not have focused on that as much as I should have in my testimony. This is one of those sets of testimony that were 3 sets of testimony filed in 6 business days that Mr. France referred to earlier. So I'll take the blame though. But so for, my thoughts on this issue from the very beginning were about affordability. And I know that's in the eye of the beholder. But it's, I wanted to ensure that customers weren't going to be facing, $25 or $50 a month. It was just, and even $5 or $10 a month to some customers is a big deal. But I would say that if you had to, if it comes to something as important as heating your home, and you're on an average budget billing program, I would say a very large percentage of customers will be able to squeeze in one place or another and come up with $10 a month. And so, that's been, I'd say, the guiding North Star behind our thoughts from the very beginning is, how can we get this payment plan down to something that the vast majority of customers will be able to budget for, will be able to handle on a personal basis. And that's mainly it. And so, for instance, there are other utilities so there were, the city of Eskridge took out a 10-year payment plan from the state of Kansas, actually, right? I mean, they received a low interest loan from the state of Kansas and basically set up a financial plan that allows them to pay that bill over 10 years. And they have a very similar customer impact that Black Hills has, actually, with a 5-year plan. Southern Pioneer, that's pending before the commission, they've requested to repay over 3 years. And I think their customer impact is like $7 a month. And so, it's, as long as you get into the realm of something that most customers should be able to afford or find a way to afford, then the time period for repayment isn't really that critical in my mind. As long as customers can afford it. But when you get into the question of longer term repayments, and in some of those same discussions that I've had with utilities, it's been, if we're going to talk about securitization and we're going to go to the effort of, and the cost and the drain on resources to actually utilize that tool, that financing tool with very, very low interest rates, then we might as well take advantage of the fact that if we can pay back this loan over 10 years, but the cost is only 1.5% or 2%, well, then maybe we should, and so these are not questions that lend themselves to objectively determined answers. This is all definitely in the subjective policy realm of regulatory decision making. But that's been my personal thought. When KGS has a meeting before their filing and says, "What do you guys think about time period of repayment?" My honest response to them was, if we're going to use securitization, let's stretch it out some, let's stretch it out to 7 or 10 years and take advantage of that. And so, but on the other hand, there is intergenerational inequity concerns that, people are going to raise of, you have this specter out there of, this has never happened before in the history of natural gas markets. We've never had this happen to this degree before, ever. Will it happen again in the future? I hope not. But to Commissioner Keene's point, I guess it's possible that it could happen this winter or the following winter or the following winter. And the longer in time you go, logically, it seems that it's more likely that next time is going to happen. And so, that I think is an important consideration of, if we pay this off over 28 years, then what happens if there's another event in 6 years or 13 years? Now we're paying for 2 of these things, and I think the other thing, Chair, as you're aware, is you have utilities in Oklahoma, and I actually think Oklahoma was the absolutely worst hit state. Texas had some quite severe impacts, and even though it got cold down there, it didn't get quite as cold down there as it did in Oklahoma. And people don't use quite as much natural gas in Texas as they do in Oklahoma. You had some Oklahoma utilities that just got absolutely hammered with their gas costs. And so for some of those utilities, it probably, in order to achieve that affordability goal that I was talking about, the only option is to go to 28 years, but as crazy as it sounds to think that we were actually fortunate compared to what happened to those utilities, if our gas utilities had to pay, on Tuesday, February 16th, on Wednesday, February 17th, when the price was $625 on the Southern Star Index, it was like $940 or in the 900s at the One Oak Gas Terminal hub in Tulsa. And then on Thursday, gas day 18, it was over $1,000. And that's when our index was back down to $44, right? And so and they had those extremely high prices all during that long 4-day holiday weekend too. So, I almost hesitate to even say it, but God forbid, if we had those kind of impacts, then we would be looking at 15 or 20 years too, because, we do whatever it takes to keep that customer bill impact below and something that's affordable.
I appreciate that context. It's a difficult question. No easy answers. Well, I believe that comes to the end of my questions for you, Mr. Grady. If I don't believe there are any other commissioner questions at this time, and so we will move to see if there are any follow-up questions from the parties based within the scope of commissioner questions. And I have on my list, Black Hills first. Do you have any questions for Mr. Grady, Mr. Flaherty?
No questions, thanks.
Thank you. Kansas Attorney General's Office.
No questions from the Attorney General. Thank you.
Citizens Utility Ratepayer Board.
No questions from Curb.
And then finally, I have staff, if you have any redirect for Mr. Grady.
We do not. Thank you.
All right. I am not seeing any waving hands from commissioners with, with any burning desire to follow up on anything. So, Mr. Grady, I believe this concludes your testimony and you may step down.
Thank you.
Let me just ask before we conclude the hearing, are there any final matters or concluding matters the parties need us to consider before we conclude the hearing?
Nothing from Black Hills. Thank you.
Thank you. I'm not seeing any other hands. So at this time, this concludes our hearing and the consolidated docket numbers 21 BHCG 334 GIG and 21 BHCG 370 MIS. And as a reminder, we are not anticipating the filing of post-hearing briefs. A commission order in this docket is due by January 22nd, 2022. And if there are no further matters, we are now adjourned and off the record. Thank you all.
Thank you, everyone.
Thanks.